you're present, the attorney's office is present. How's it coming along?
I emailed them to the 21 Orange address, Your Honor.
Okay. The one that says revised jury instruction. All right. Schwartz says the defense had a chance to go through these.
Judge, we're going through them now.
Okay.
We did have an issue I just pointed out 2 seconds ago to the state with one of them. For the justifiable use of force, Judge, is this coming through any better?
Go ahead.
Judge, do you have it open? I'll tell you where to go on yours.
Well, I just opened the jury instructions, and for some reason I have 2.1 preliminary instructions as my first page.
I apologize, Your Honor. I sent the whole packet, and I didn't cut out the first,
Okay.
the preliminaries.
Tell me what page this is on.
All the way at the end, Judge, go to 74.
So we're in justifiable use of force. 3.6F.
That's it, Judge.
Okay, go ahead.
So if you go down, let's see, if you go down a few pages, that starts on 71, so if you go down to the 74th page, I believe, there's a paragraph, it's a very short paragraph, begins with the word, however, the use of deadly force is not justified.
Yes.
So the remaining part is if you find that Markeith Loyd was attempting to committing, or escaping after the commission of a murder, that doesn't have any application for the first 3 counts. Sure. So this says that he isn't justified if you find out that, if you find that he was attempting to commit or escaping after the commission of murder. So that cautionary instruction, let's call it, that has nothing to do with counts 1, 2, or 3. So I'm concerned if we have it in there, it's going to be a bit confusing to the jury. So if they read that, and if you take it just by what it says, he can't use deadly force if he was attempting to committing, or escaping after the commission of a murder.
But that's where you're using it. Counts 1, 2, 3 are the murder and attempted murder counts. So why doesn't this apply to everything?
Because there's no evidence that he was escaping from a murder while committing the murder.
So you're just talking about the escaping after commission of murder?
The whole sentence. So let me see if I could phrase it better.
In count 1, he's being accused of committing murder. In count 2, he's being accused of committing murder. And in count 3, he's being accused of attempting to commit murder. So forget the escaping part. Tell me why attempting or committing doesn't apply to counts
In this case, Judge, it's my reading of this is that the whole thing has to do with escaping.
It's an or, not an and.
Understood, Judge. But then, again, if you don't read it that way, you're still left with deadly force isn't justified if he was committing murder.
Uh-huh.
I don't think that makes a lot of sense when the offense itself is murder. So that would make sense, for example, if he were attempting to commit, let's say, murder for person A, and he also murders person B. In that case, I don't think the deadly force would be justified. But here, I think it's a little too confusing. If nothing else, you are right. The escaping part is more troublesome than the first two clauses.
The escaping part would apply to the attempted felony murder counts.
Correct, 4 and 5.
Right. State.
You know, it may
I
be a
don't know,
little,
Your Honor.
Judge, it may make a little more sense if you look at, for example, the 6.3. So for count 4, the instruction is to prove attempted felony murder, the state needs to prove that Markeith Loyd committed or attempted to commit murder while engaged in commission, attempted commission, or escape from the immediate scene of a murder. So my concern is that language is a little too confusing and too similar as the language that's used in what I had mentioned before from the justifiable use of force instruction.
All right, let me try and parse this out. I need to make sure that I understand what your
Sure.
argument is. Are you arguing that this paragraph, which reads in its totality, quote, however, comma, the use of deadly force is not justified if you find that Markeith Loyd was attempting to commit, comma, committing, comma, or escaping after the commission of murder, period, close quote? Is your argument that this paragraph does not apply to counts 1, 2, and 3?
Correct.
It only applies to 4 and 5?
Correct.
All right, let me start with that. State your response to that.
And that's under the aggressor section in the standard jury instructions. And give me 1 second, Your Honor.
I'm trying to open my standard jury instructions. Here we go.
But I don't know how to fix it. Is the defense requesting to just take out was attempting to commit in the word committing and just leave escape?
No, the escape is a part that I don't think should be there. I think the escape definitely doesn't have any relevance for 1, 2, and 3.
But you just said you think the whole, let me try this again. Are you objecting to this entire paragraph?
Yes.
Okay. And what is the basis of your objection as to count 1?
There's no evidence that at any point he was escaping after the commission of...
So as to count 1, are you objecting only to the words or escaping after the commission of murder?
1 second. So I'm objecting to the entire thing. For this one, Judge, the precursor in the standard says, let's see, it says, give if applicable and only in cases where he is charged with either an independent forcible felony or felony murder if the underlying felony is an independent forcible felony.
Judge, I think my reading of this section is the defendant is not justified in claiming use of deadly force if the jury finds that he was committing or attempting to commit a murder because he is then the initial aggressor, and something that happens afterwards, he doesn't get to then claim self-defense. That's why it's under the aggressor section.
Only in cases where the defendant is charged with either A, an independent forcible felony, or B, felony murder if the underlying felony is an independent forcible felony.
Like robbery?
Well, in this
It's
case,
very
murder.
helpful.
No, that's not.
So, I mean, I think this applies where there's another felony that's underlying the murder.
Okay, so according to the statute itself, 776.0411, in order for this to apply, Mr. Loyd would have to be the aggressor. So if a person is the aggressor, is attempting to commit murder.
Your Honor, my read, I don't want to interrupt you.
Go ahead, yeah.
My reading is if he is the aggressor
Right.
in the commission or attempted commission of the forcible felony,
Right,
which in this case, the way it's charged would be the murder of Ms. Dixon, her child, or the attempted murder of Ronald Stewart,
correct.
he is then the aggressor of that underlying forcible felony. He does not then get to claim self-defense as to the attempted felony murder of Stephanie Dixon Daniels and Dominique Daniels.
Right, so this paragraph
Applies to counts 4 and 5.
only to counts 4 and 5.
I agree with the defense, and I see their dilemma about that. So if we can delineate that, something to the effect of, as to counts 4 and 5,
Correct. I agree with the defense that this only applies to counts 4 and 5, and the way it reads right now, the jury could think it's applying to 1, 2, and 3.
understood.
So, what's your proposal for fixing this?
I could put in, as to counts 4 and 5, however, the use of deadly force, and continue the paragraph.
Mr. Schwartz?
As long as the final sentence will be, this paragraph is not applicable for counts 1, 2, and 3.
I think that's what as to counts 4 and 5 only.
I understand, Judge. I'm of the opinion it's better to have more than less when we're telling them.
That's because you don't have to read the jury instructions. Mr. Schwartz. All right, as to counts 4 and 5 only, the use of deadly force, and then there would be a comma, the use of deadly force is not justified if you find that Markeith Loyd was attempting to committing, or escaping after the commission of murder.
I believe that's an accurate statement of the law and what the instruction is meant to.
And you wanted to go on and say, this does not apply to counts 1, 2, and 3?
It just confuses things.
What?
That just confuses things even more.
Yeah, that actually, listen to it if I read it out loud. With jury instructions I've learned over the years, you have to actually hear them. As to counts 4 and 5 only, the use of deadly force is not justified if you find that Markeith Loyd was attempting to committing, or escaping after the commission of murder. This does not apply to counts 1, 2, and 3.
I understand what you're saying. I hear what you're saying.
It's dangling sentence.
Right, I hear what you're saying.
So are you good with as to counts 4 and 5 only?
Yes.
Okay.
One thing maybe that I want change, though, would be if we go back to the very first paragraph for 3.6F, then maybe something just,
Hold on. All right.
maybe something along the lines of, it's a defense to all of the crimes charged and any lesser included offenses.
An issue in this case is whether Markeith Loyd acted in self-defense. It is a defense to the crime charged and any lesser included offenses if the actions of Markeith Loyd constituted the justifiable use of deadly force.
It should say crimes. It should say crimes,
It
plural.
should say crimes, yeah. But portions of this do apply to 1, 2, and 3, and 4 and 5.
You're referring to portions of 3.6F?
Yes.
Sure.
So what is it that you're objecting to?
I would just add in it's a defense to all of the crimes charged.
well, then it doesn't include this lesser included, which it does.
No, what he wants it to read is, it is a defense to all the crimes charged and any lesser
Okay.
included offenses. So I don't have a problem with adding that in.
Okay, that's been changed.
Okay? Anything else on 3.6? Thank you for taking out Mr. Lloyd's middle name.
Yes, ma'am.
We may change our mind on that, Judge,
On what?
the middle name. I'm just joking.
Too late. All right, you can change your mind about other things, but not that. All right, anything else on 3.6F?
I'm going through it now,
Let me-
Judge. I don't see anything
All
right now.
Let's go back to the beginning of this so that the record is clear as to this draft of the jury instructions. Let me just take it one at a time so the record's clear. All right, we're going to delete 2.1 preliminary instructions.
I have. I started at 3.1. I'm sorry, I started with closing argument, 2.7.
I don't usually give that one to the jury,
Okay.
and I have a copy of it, so
Okay,
let's save some trees and take that
I
one
keep
out.
forgetting that this court gives copies to the juries, to the
Yeah,
jury.
I do. You also have 3.8 in here. So 3.8, the one that you have at the beginning of this packet is
I've-
the old one, so that one's out too?
I have removed that.
Okay, thank you. Let me just see if I can get this to delete what I need it to delete. All right, so my jury instructions now start with 3.1. Three point one, 3.2, any objections to either of those? I'm not hearing anything. 7.1, introduction to homicide. Any objections? Not hearing any. Justifiable homicide. Any objections? Excusable homicide. Any objections? Not hearing any. Count 1, 7.2, murder in the first degree. Any objections? Not hearing any. Count 2, murder in the first degree, unborn child. Any objections from either side?
No, Your Honor.
Not hearing any objections from defense. 6.1, introduction to attempted homicide on the attempted first-degree murder and attempted felony murder. Defense, have all the changes been made that you requested?
It looks like it, Judge. I'm going through it as you're speaking.
Okay. Any objections to it?
No, Judge.
Okay. Count 3, attempted murder, we need to take the statute out.
The statutes are in most of them, Judge.
Half of them have it and the other don't.
Yeah.
So we need to be consistent.
We would just prefer to take them out, Judge.
Let's just take out the statutes.
Yes, I missed it.
All right, count 3, 6.2, attempted murder, first degree, premeditated. All changes made as requested, defense?
Yes.
Any objection to it as it now exists?
No.
Count 4, again, we're removing the statutes. Attempted felony murder, enumerated felony. This is as to Dominique Daniels. All changes made as requested, defense?
Yes.
Any objection to it as it now reads?
No.
Count 5, 6.3, attempted felony murder, enumerated felony as to Stephanie Dixon Daniels, removing the statute numbers. All changes made as requested, defense?
Yes, no objection.
No objection. 3.4, lesser included attempts, crimes or attempts. As to count 1, second-degree murder and manslaughter. One more time, is state requesting any additional lessers?
No, Your Honor.
Defense?
No, Judge.
7.4, as the lesser of count 1, second-degree murder. Any objection from defense or state, or any further changes?
No.
No, Your Honor.
7.7, manslaughter as to count 1. Any objections from state
No.
or defense?
Sorry.
No, Your Honor.
3.4, lesser included crimes or attempts as to count 2, first-degree murder of an unborn child, second-degree murder of an unborn child, and manslaughter of an unborn child. State, any other lessers requested?
No, Your Honor.
Defense?
No.
7.4, second-degree murder of an unborn child. These are the lessers. All changes made as requested, defense?
Yes.
Anything else? Any
Nope.
objections?
No objection.
State, I'm assuming you don't have an objection because you typed these. So.
Correct.
7.7, manslaughter, unborn child as to count 2. All changes made as requested, defense?
Yes.
Any objections?
None.
3.4, lesser included as to count 3, attempted first-degree murder. We have attempted second-degree murder, aggravated battery, and attempted manslaughter by act. It's in the correct order, the
It
levels.
is.
Yeah, I checked the levels.
Thank you.
Sure. But check me one more time, okay? But any other lessers requested?
No, Your Honor.
Defense?
No.
6.4, attempted second-degree murder as to count 3. All changes requested made, defense?
Yes.
Any objections?
No.
Okay. 8.4, aggravated battery as to count 3. All changes made as requested, defense?
Yes.
Any other changes requested?
None.
Any objections?
No, Judge.
Attempted manslaughter by act. We need to take out the statute. We need to put in as to count 3. All changes requested made?
Yes.
Any other objections or changes?
No.
3.4, count 4 and 5, attempted felony murder. Lesser is attempted manslaughter by act. Any other lessers requested, state?
No, Your Honor.
Defense?
No, Judge.
Any objections to attempted manslaughter by act as to, you
No.
don't have to do the, oh yeah, you do, because it's two different victims, sorry. Attempted manslaughter by act as to count 4 and as to count 5.
No.
3.3D, possession of firearm, discharge of a firearm. Let's take out the statute. All right. Let me read this one. Okay, you appear to be repeating paragraphs, unless I'm...
The first paragraph deals with Ms. Dixon and her child, and
Correct.
possession, discharge, great bodily harm. The second deals with Ron Stewart.
Oh, you broke it up, you're right. You broke it up into discharge, possession, discharge of great bodily harm. Now you're discharge
Correct.
of a firearm. Okay,
I think that's how the standard reads, but I
It
broke it
is.
up into victims.
actually it's misspelled in, it should be showing up on your screen. On actually possessed a firearm, Ron Stewart. There's just an additional R in there.
I have it.
Got it. All right, so firearm is legally defined. Defense, all changes made as requested.
Looks like it, Judge.
I'm sorry?
Looks like it, Judge. I'm
Do you have
reading
any
it.
other objections?
No.
3.3A, aggravation of a felony by carrying a firearm. This is all of the alleged victims. As to manslaughter and attempted manslaughter by act. Any objection?
No.
Plea of guilty, reasonable doubt, the change ordered by the court as to reasonable doubt was changed. Any other objections or changes requested by either party?
No.
Okay. Weighing the evidence, we have 1 through 8. Other than the request you already made and the objection you already made, do you have any other objections to this instruction?
Nothing further.
Okay. 3.10, rules for deliberation. Any further changes requested by either party?
No.
No, Your Honor.
Cautionary instruction.
No.
That one's just a basic. 3.12, verdict. You got to take out read verdict forms, which is just an instruction to the court.
Yes, ma'am. Should I take out they are as follows also?
No, just they are as follows, and then I go over it with them. In addition, their special verdict forms for counts 1 through 5. All right, and that brings us to the verdict forms. Any objections to the verdict as to count 1?
No.
The form, I'm sorry. Count 2? Was that an or?
Yeah, I'm just looking, the verdict form has the letter A next to his name in parentheticals.
It does.
It does.
Our system generates it that way. I will take it out.
We'll need to check the cover page of this. Right, so other than that, any objection as to verdicts as to count 1 and 2?
No.
Count 3?
No, same thing.
Yeah, we're taking out the A. Count 4, other than taking out the
No.
A, and 5.
No.
It's weird, some of it has it and some doesn't. Special verdict forms. Count 1. There's 2. One is for manslaughter, the other's for second-degree murder. Any objection?
No.
I don't think this is, oh, there it is. Second-degree murder, unborn child. Wait a minute. Did you get all of the? Are these verdict form, the special verdict forms, do they cover all the charges that?
They should. The second degree for the unborn child, there's one verdict for the 1020 life, one verdict for the manslaughter enhancement. That's the lesser.
Okay. All right, so count 3, oh, there it is. Attempted first-degree murder, second-degree murder, and ag battery on count 3, and attempted manslaughter by act. Any objections to those? Just
No
taking out the A on Mr.
No, I have no objection. Just going back quickly, and this not sold either way, but I don't know if there's any benefit in count 1 in putting Ms. Dixon's name here.
The what?
If you go back to count 1, it just, for all the count 1s, there's no mention of Sade, Dixon. I don't know if it makes sense to add everybody's names so they don't get mixed up with some of these counts.
I have no strong feelings one way or another. I mean, he's saying,
You don't want the names in?
no, he's saying, put the names in. He's saying, is there any benefit to adding the names?
Just for clarity purposes, for when they're going through them.
On the special findings or the verdict forms?
I'm looking now. It would be on the special findings and
I put the names in as far as when we're describing great bodily harm or death to the victim.
right. I don't know if there's a benefit on the verdict form also and just putting the person's name next to the count to distinguish.
I think they can go back to the
Fine.
instruction as to count 3.
Fine.
I don't have a strong feeling about this one.
I don't either. I'm just throwing it out there.
Yeah, other than that, any objections to the special verdict forms to count 4
No.
and count 5?
No.
Okay. I don't know why this thing. All right, so the verdict forms, there's no objection to them, other than wherever there's that random A after Mr. Lloyd's name, we're taking it out. .12A, single defendant, multiple counts.
No.
Legally interlocking counts, 3.12D.
No.
3.13, submitting case to the jury.
Nope.
All right, then we have 3.8, the modified version of it,
Nope.
and 3.6F, justifiable use of deadly force with the changes we just did in the courtroom. Any
No.
other changes? All right. Anything else on jury instructions? Do we have a final set of jury instructions?
I hope so.
What?
I hope so.
I'm just waiting to hear from the defense.
I don't have any objections, Judge, at this
Okay.
point.
We have a final set of jury instructions. Only, the way you've got this set up, you're going to end up printing a whole bunch of verdict forms you don't need. All right, you just need one set of verdict forms.
Yes, ma'am.
We've got 14 jurors left standing. The court, do you want a set of jury instructions? Are you doing tomorrow? Okay, so we need 14 for the jury, 1 for me. You counted 25?
25.
All
I
right,
was told 25.
25, yeah, that's a lot of, do not staple them together because I'm going to change the order that they're printing in. So please don't staple them, because 3.6 doesn't go at the end, it goes in the middle. So if you're going to reorder them in the correct order and then staple them, that's fine. Like put 3.6 where it belongs and 3.8 where it belongs.
I can do that.
Okay, that would be great. And then just one set of verdict forms for me. Obviously, if you all want a set of verdict forms, that's fine. I just don't want the jury to have them.
On the last page, there's the second paragraph from the top, there's just a phrase, insert offense within brackets.
There's what?
The phrase, insert offense is bracketed in the first sentence of the second paragraph.
Yes.
On the last page of the instructions?
I noticed that, Your Honor, and I didn't go back and change that. What would the defense like?
I guess just alleged offenses is fine.
I'm sorry?
I think alleged offenses is probably fine. If you find that a town, the alleged offenses.
Well, it would have to be alleged crimes because we can't switch from offenses. We can't switch from crimes to offenses, so.
If I just put alleged crimes, is that okay?
That's fine.
All right. Anything else?
No, just the same objection from before about the stand your ground.
Yes. No conversation that I had with you this afternoon is intended to be read as you waiving your prior objections. All right. Let me get back to this motion in limine by the state. Mr. Lenneman, I believe that the source of the confusion between you and I is that we are in the Fifth, and the Fifth Circuit has some different rules about text. I have for you the case of the state of Roy versus state of Florida. It's 219 Westlaw 3849373, 5th District Court of Appeals, filed in 2019. These texts that the defense introduced came from Sade Dixon's phone, not from Markeith Loyd's phone. All right? The fact that a search warrant was executed on them certainly is part of the predicate. But to summarize all of this, in this DCA, you have to authenticate the text, and you can do it one of two ways. One, the person sending the text or receiving the text can say, these are my texts. Clearly, Ms. Dixon is unable to do that because Ms. Dixon is deceased. Mr. Loyd authenticated the text when he was on the stand, which made them clearly admissible. He said these were his texts. The other way that you can authenticate text is by content. I'm sorry, did somebody ask for? Oh, I thought one of you was asking a question. Okay, is by content. I reviewed the text that you introduced into evidence, and this, of course, is to the issue of whether the state would have even been able to introduce these texts during
Those
your
aren't the
case.
texts you're looking at.
Hold on. Exhibit 11,
That's not the text.
what is this?
Those are the Facebook messages she sent
Okay.
after she.
So the only texts are Exhibit 13?
Yes, those are, I think those are.
My issue with these is that there is no independent way for the state to have met the predicate required and introduce these texts because Ms. Dixon these came from Ms. Dixon's phone to Mr. Loyd, correct? There's nothing in the content of these that identifies them. The receiver as Markeith Loyd, it could have been almost anyone with whom she was having a conversation. Now, if I'm missing something on there, I'm more than willing to hear you out.
I don't even know what those are.
I asked for the text you introduced. Okay, those are the ones I was talking about. So they're the exhibit I originally said? All right. So the text on Exhibit 11, the content of these texts based on the evidence that was introduced in the case, could have been authenticated by content. So I'll let you talk about these texts in closing, as the state not having introduced them.
Yeah, that's all I want to do.
Okay, so they could be authenticated by content, but in the Fifth, you can't authenticate just because there was a search warrant. Okay?
So I can talk about them in terms of that I introduced them, they did.
Correct, but the state then gets to rebut
That's fine.
and talk about whatever they want to talk about as to why those texts did not come in. All right? State, I'm sorry, I didn't even ask you, is there anything else you all wanted to put on the record about that?
No, Your Honor. Thank you.
All right, thank you all very much. Anything else we need to resolve before tomorrow morning? All right, let me tell you all how I read jury instructions, which I've been affirmed on repeatedly. I am not going to read 3.4 over and over again. All I do is tell them, this is the same instruction I just read you. It is as to count two. I'll read it the first time. The second time I'll tell them, as to count two, the lessers are these, and then I'll read the lessers. Certain portions of the instructions are repeated over and over again. What I call the provocation section is the same in every single instruction. So what I read it the first time, and then after that I tell them, this is the same as what I read you on first-degree murder. You have it in writing. As long as the jury has it in writing, we're fine. It will cut this down from what is going to be a lengthy read anyway to one that is going to require a break in the middle, because it's 75 pages of jury instructions. So I just want to let you know ahead of time, that's why I'm going to say that and skip. I will stop reading when I get to 3.10. You all will do I'll read the closing instruction then. You all will do your closings, and then I'll finish reading the remainder of the instructions, which isn't much, and going over the verdict forms with them. You're free to use the instructions and the verdict forms in your closings. Lawyers sometimes ask me that. I have no objection to that. Even though I haven't gone over the verdict forms with them, you can use them as long as they're the verdict forms that I'm going to give them. Any questions about closings or instructions?
No, Your Honor.
No?
No, ma'am.
All right, good luck getting your closings ready. How long do you think you're going to take? Who's doing it?
I am, Your Honor.
Mr. Buxman, how long do you think it's going to take?
Total, hour and a half.
Okay, and Mr. Lenneman?
I'll try to stay within the hour and a half as well.
Okay. So we start at 9. We'll take a break after yours, just to give everybody a break. The court reporter will need one too. So we should be done by 12, 12:30, if you all stick to your time frames. We'll see how you do. All right? I don't call time for attorneys unless you want me to. And, I don't count down to the second. Like at the hour and a half mark, I'm not going to be screaming, you must sit down. If you start to go wildly over, then you'll hear from me. But other than that, a few minutes here or there doesn't bother me one way or another. Okay?
Yes, Your Honor.
All right. Have a good evening, folks. I'll see you all at 9 a.m.